तस्लीम कर रहे हैं, और आप ये कह रहे हैं पार्लियामान दे सकती है मगर सिर्फ थोड़ा सा फर्क रह गया है। नहीं सुनिए, सिंपल मेजॉरिटी से नहीं करेगी, वो करेगी 2/3 मेजॉरिटी, बस यही फर्क रह गया ना अब, क्योंकि अमेंडमेंट आ गया ना कॉन्स्टिट्यूशन का, बस इतना फर्क आ गया ना। कर सकती है मगर तरीके कार गलत है, और यही असल क्वेश्चन था एजाज साहब का। और मैं बार बार कह रहा हूँ असल क्वेश्चन ये है, आप लोग इधर उधर जा रहे हैं, जो अपना केस मेरे हिसाब से आप कमजोर कर रहे हैं। अगर आप उधर ही ठहरते तो शायद आपकी आसानी होती, मगर आप क्योंकि अब हमें उधर ले गए तो सवाल फिर उठते जाएंगे।
मैं तो भी अपील वाली प्रोविजन पे एक्चुअली आया ही नहीं था।
अपील पर आप आए हैं मिस्टर भंडारी, अपील पर आए हैं तो फिर सवाल, आई विल आल्सो गो बैक टू माय ओरिजिनल क्वेश्चन दैट अगर राइट ऑफ अपील सब्सटैंटिव राइट दी है तो वो सब्सटैंटिव राइट को कंट्रोल कैसे कर रहा है एक कमिटी ऑफ 3 जजेस which can then decide कि कितने साइज बेंच बैठेगा और उस राइट को ब्लॉक कर देगा. So then that substantive right of appeal which we want people to have, which they have a right to have under this law, that has been blocked even in this case. There is a full court sitting, there is no right of appeal now because that right has been totally blocked. So what was the purpose of creating that right? This is a question that I'm waiting for the Attorney General to answer. But just to ask you this question from this side as well, what would you answer to that?
Well, for me that absolutely highlights the problem with this provision. An administrative power will be used and has been used to completely stultify the exercise of judicial power.
The court can never say that 10 judges बैठेंगे, 11 बैठेंगे, because वो appeal हो ही नहीं सकेगी.
I take it one point further. If the right of appeal has to be provided in every case, right now the sanction strength is 17. That means 9 judges have always to be available to hear an appeal. The largest bench that can be constituted is therefore an 8-member bench.
Your argument is basically flawed. I'll tell you why it is.
Well, let me complete it.
No, because I'll point out the flaw.
Let me complete it.
No, because आप आगे नहीं बढ़ सकेंगे. I'll tell you what the flaw in the argument is. The basic argument is flawed. Why is it flawed? First of all, you say the law is good because it's given a right of appeal.
I don't say that.
ठहर जाइए ना, ये क्वेश्चन अराइज ही नहीं होगा ना, वो अभी तो अपील है ही नहीं ना, तो ये हमारे ऑर्डर की अपील कहाँ जाएगी, वो तो सवाल ही नहीं पैदा होते हैं ना। अभी इस मौजूदा सूरत हाल में अगर ये कानून है ही नहीं तो कोई राइट ऑफ अपील नहीं, खत्म। चाहे वो 5 के साथ सुने या 10 के साथ सुने या फुल बेंच सुने या कितने नंबर हैं वो सुने, वो तो सवाल ही नहीं पैदा होता। तो ये कानून पहली दफा ये एक राइट ऑफ अपील दे रही है। अब आपका कहना कि क्योंकि ये कानून राइट ऑफ अपील दे रही है मगर इस केसेस में तो राइट ऑफ अपील होएगी नहीं, सिंपल जवाब है बिल्कुल सही बात है। क्योंकि अगर 17 जजेस या फुल कोर्ट भी इतनी बड़ी गलतियां करने लगे तो फिर राइट ऑफ अपील होना ही नहीं चाहिए। एक तो जवाब ये हो सकता है। दूसरी बात है कि हम वी कैन इमीडिएटली रीड दैट इनटू द कॉन्स्टिट्यूशन कि भाई नेचुरली अपील नहीं है। अगर जो आपने हमें 2 केसेस दिए, हवाला दिए यूसुफ रजा गिलानी वाला, तो पहले बेंच थी 7 की, दूसरी बेंच बनी 8 की, तो इफेक्टिवली सुप्रीम कोर्ट ने वही काम किया जो ये कानून करता है, इससे ज्यादा तो नहीं किया। कानून भी यही कह रहा है कि राइट ऑफ अपील, तो ये मफरूजा पहले हम खड़ा करें, राइट ऑफ अपील किधर जाएगी? बिल्कुल नहीं होगी, खत्म, घर जाओ। अगर हमने सब फुल कोर्ट ने कर दिया या इस मिकदार में जजेस ने कर दिया कि वो अपील नहीं होगे, इसीलिए हम बहुत एहतियात से काम करते हैं कि ऐसे केस में तो राइट ऑफ अपील का सवाल नहीं पैदा होता। ये तो एकेडमिक एक्सरसाइज है हमारे इख्तियार की। मगर जहां आप कोई अपना कोई केस लाएं, फॉर इंस्टेंस आप अपनी पार्टी का, अगर हमने फुल कोर्ट बिठा दी तो बात खत्म हो जाएगी, ठीक है। तो वो हम किसी की राइट ऑफ अपील तो है ही नहीं। तो पहली बात तो पार्लियामेंट ने दी है, तो अब कहना कि 99% दे दी तो 1% बच गया तो इसलिए बेकार हो गया, इसलिए लॉ खराब है। इसलिए मैं आपको कह रहा हूँ आपका आर्ग्यूमेंट फंडामेंटली फ्लॉड है। आप मेरी बात समझ गए हैं मैं क्या कहना चाह रहा हूँ?
बट ये मेरा आर्गुमेंट है ही नहीं ना जी। मैं ये कर रहा हूँ, मैं फुल कोर्ट पे जा ही नहीं रहा हूँ। मैं फुल कोर्ट में ठीक है, फुल कोर्ट आप बैठ के फैसला कर दें, उसके ऊपर कोई
इसका फायदा कुछ नहीं। एक कॉम्पिटेंस का इशू पहले हल कर लें।
मैं एक बिकॉज़
क्रॉस द कॉम्पिटेंस देन वी गेट इनटू दिस क्वेश्चन।
मैं तो जी अब सवाल आ रहे हैं तो जवाब तो देने,
इसका फायदा तब होगा ना।
मैं एक इसका मेरा एक और फंडामेंटल इशू है जो मैं कह रहा हूँ।
आप बताएं।
Assuming this law, your lordships uphold this law, for let's assume for the sake, then the right of appeal is there. Then in every case under 184(3) you have to make provision for 9 judges out so that they can hear an appeal. Therefore the maximum strength of the bench can always be 8 or not more. What will happen in that case to judgments that your lordships have delivered by 10 member, 11 member, 12
No
member,
appeal.
13 member benches.
No appeal.
Can you never overrule those judgments then?
Overrule is different. देखिए अब आप फर्क में आ गए।
तो किसी और
that's-
वो अगर हम
that's
किसी
a
और केस
curtailment
में
of your-
बैठकर
That's a curtailment of your judicial power. Is what I'm
overrule तो
arguing.
किसी
right
और
of
केस
appeal
में
is a different thing, and right of interpretation and learning from mistakes or becoming wiser is altogether
Why
different
not
thing.
allow me to articulate my point? My point is that if you are stuck with a maximum of 8 or 9 judges in a bench, you can't create a bench larger than 9 in under any circumstances, then you can never overrule larger bench judgments, and that's a
आपको
curtailment of your...
घबराहट क्यों हो रही है अगर राइट ऑफ अपील मिल गई?
मतलब
आप एज अ पॉलिटिकल पार्टी आपको क्या फर्क पड़ रहा है? हो सकता है आप फायदे में से हो किसी केसेस में।
जरूर फिर आप ये दो जजमेंट्स मैंने दी हैं सर, इनको भी ओवररूल कर ले, प्रोविंस को भी अपील
आपसे मैं पूछ रहा हूँ एज अ पॉलिटिकल पार्टी आपको फायदा या नुकसान क्या हो रहा है?
फायदा नुकसान की बात नहीं है जी।
नहीं, हो रहा है तो बता दें।
We are only कोई फायदा नुकसान नहीं है, सिर्फ the only concern is that parliament and my client today it's going through difficult times, but it can be in power again. It can be in power again. The history of Pakistan teaches us this. So even then I'm under instructions to say that this is not something that the parliament should be allowed.
ये जो बात आप कर रहे हैं ना, I'm under instructions to state, sorry, हम ये बिल्कुल नहीं एक्सेप्ट करेंगे। इस किस्म की नौयत के केसेस में you are not under any instructions. You appear to assist the court. ठीक है?
I do that.
ठीक है, तो your client can say stand on your head or whatever. I'm not concerned with that. This is not his rights or that party's rights that we're talking about, that you can give instructions. जब आपने ये तय कर लिया है कि कोई उनका इंटरेस्ट नहीं है, तो फिर आप ये नहीं कहें साथ साथ I'm under instructions to state. Sorry to say आप मातहत नहीं हैं. You are an officer of this court first and foremost. And in this case, the matter ends there. Doesn't go beyond that.
My lord, that goes, your lordship, when I first stood here on the last date, your lordship asked me a question, who are you with? And I said, I'm supporting the petitioners, but with some caveats. That's all I'm saying. That all that I've said, the legal submissions I made are not
in the instructions का लफ्ज़ ना इस्तेमाल करें.
I'll take that. But the position is that Parliament should not have this power because it may not be used in a benign manner tomorrow. That's the only concern.
In other words, we will not use it properly, the right of appeal.
No, not your lordship, not you. Who is to stop Parliament from?
कल आएगा वो वाला लॉ, फिर आप देख लेंगे. हमने कोई ब्लैंकेट अथॉरिटी तो नहीं दे रहे हैं.
इस कोर्ट पे इसी कमरे में फिजिकल अटैक्स भी हुए हैं. पार्लियामेंट में जो होता रहा,
sorry, please stay focused. ये बातें ना करें ना.
उसके लिए आप पार्लियामेंट को, इसीलिए ये फायरवॉल क्रिएट की गई है अगेंस्ट टू प्रोटेक्ट द जुडिशरी. दैट्स ऑल आई एम सेइंग. पार्लियामेंट अपने डोमेन में रह के हजार चीजें करे.
हम प्रोटेक्ट करना चाहते हैं पार्लियामेंट को भी.
जरूर करें. मैं आई एम ऑल फॉर इट. इसीलिए तो मैंने आपको एंट्री 55 में से एक रास्ता देने की कोशिश की है, which goes against what the case law of this court says.
Under the constitutional scheme, each organ of the state has been provided the bar to make its own rules. The judiciary doesn't make the rules of the parliament. The judiciary doesn't make the rules of the executive. The judiciary makes its own rules.
Yes,
right? Only those rules made by the executive or other organs which are in conflict with the constitution can be looked at by us, and if we find they conflict with the constitution, they have to be struck down. So those three firewalls have been intentionally, deliberately created by the constitution, and the interest of every citizen of the state is that they remain intact.
Absolutely, my lord.
Number two, substantive right hai, right of appeal. My question is, how can a procedural law, even if it is not ultra vires, provide such an appeal?
It can't. It can't.
Now, Mr. Uzair, if I understand you correctly, and I just want to close this point here, that you're saying that for the purposes of substantive right to appeal, entry 55, we have to, the law has to pass the test of entry 55, and entry 55, then you also say that there are two problems with it which are still unclear and unanswered. One is that there has to be express provision. Under the law is not clear, and it is not clear how jurisdiction is being vested in the Supreme Court through other statutes. So while we rely on 55 for this, 55 itself is shrouded in a bit of a mystery, and there are unanswered questions.
Yes.
Is that right?
Yes.
Thank you.
Mr. Bhandari,
Now, assuming that this power to make law under 191 is an enabling power, the subject matter is the practice and procedure of the court. So, could it be said that the power of the court, the rule-making power, in respect of this subject matter, and the power, if this is an enabling power of Parliament to make a law, are coterminous, meaning they extend over exactly the same area?
My lord, I would say no, because then once Parliament covers everything, then there is nothing.
I'm not saying, what I'm saying is, whatever is the subject matter of the practice and procedure of the court has the power to make rules in that regard.
My lord.
If law as used in 191 is an enabling power, it operates on the same subject matter, and the area therefore is the same.
If it is used as an enabling provision,
Yes, yes.
then yes.
But then if that is so, you have just told us, and quite rightly so, that in exercise of rule-making power, the Supreme Court cannot give a right of appeal.
Can't.
So therefore, if the two powers are coterminous in respect of the subject matter, my question to you is, how can, if it is an enabling power, how can Parliament use Article 191, because that is what is referred to in the
Yes.
preamble, how can it use that power to confer a substantive right of appeal? How is that possible?
It can't. It can't be.
So I agree with the comment made by my little brother, but and just adding to that, to the extent of practice and procedure, if we were to take 191 to be an enabling power, then to the extent of practice and procedure, the law is correct. As far as the substantive provision of appeal is concerned, we'll have to look the other way, and then we'll have to look at 55, which, as I had earlier said, is already full of confusion and not very clear. So that's that. But as far as the law and practice and procedure is concerned, if we were to imagine that 191 is an enabling provision, then the law passes the test, the committee and all the other provisions, except the substantive part of appeal, which is still unanswered, and we wait for the others to
My lord,
explain.
even then, that's why I added a caveat at the outset that even if it is an enabling provision and enables Parliament to enact a statute for rules and procedure on the basis of 191 itself, it will still be subject to some all overarching constitutional principles. Now, one constitution.
That's fine.
My lord, allow me to finish this. One overarching constitutional principle, which in my humble opinion, and that's what I've submitted, has acquired the status of a constitutional convention, is the power of the Chief Justice to form benches. Now, I'm not saying that should not be, I'm not for a moment saying that. I'm saying that since that has achieved the status of a constitutional convention, that constitutional convention is being continued by virtue of the provisions of Order 11 rules. Therefore, the Parliament can't undo that, as held by Baz Muhammad Kakar. Your lordships will have to do that in exercise of rule framing power.
So आपका जो point है ना, suppose if we were to take 191 to be an enabling power, then we look at the law and we look at the Master of Fundamental Rights. I would agree with my little brother who would refer to my earlier order relating to the committee deciding the thing, which is I'm very clear on that issue. There could be either that has provision, could be, speaking for myself, read down, or we're not sure whether at all they judicially decide this question or administratively decide this question. One would imagine because it's a committee, it is more of an administrative thing.
Yes.
That's a snag which needs to be rectified, but that's that.
Yes,
Can I just place a conundrum before you, and if you can respond to it? This is the first one. This is the first one which directly affects me.
Okay.
Since everyone is very kind on both sides of me, and all of you are very kind, let's suppose I, in the person of the Chief Justice, become very unreasonable. All my colleagues ask me to call a full court meeting to amend certain rule which requires amendment, okay, or some other issue. I say, no, I will not do it. So there is, nobody can do anything about it, pehli baat. So when we talk about, there are two arguments. One is trichotomy of powers. Then within a particular constitutional body like the Supreme Court, Yes, I can go along with the first one, but then are you also propagating the omnipotency to the Chief Justice, or as used to be criticized, the Lord Chancellor of England and the equity varies with the Chancellor's foot? So suppose I become unreasonable, tough luck to all of you, to everyone in Pakistan, tough luck. Right?
No, not at all.
How will you resolve this?
My lord.
Parliament has said, well, you may not like it, Mr. Chief Justice, but we have made an attempt to resolve it, because you are never going to do it. You are never going to do it. And you are, by your conduct, have shown you are never going to do it. So you can say, no, we must persist on omnipotency to the Chief Justice, the person of the Chief Justice, and he can do no wrong. And let him do is it democratic? Is it just? Is it forget the Constitution of Pakistan for the time being. I'm talking now of greater concepts like justice and fairness. Does it meet? We talk about Islam, but surprisingly enough, not one person has mentioned Islam here. Does Islam even permit this? Such a powerful body of one person, unaccountable, totally. And someone legislates, the only thing I find fault with is, how dare you legislate? I can do so, but I will not do so. Now tough luck to you, Mr. Bhandari and everybody else. Do whatever you want to. So it suits me. Like I said, my colleagues are much too kind to articulate something, but I think it needs to be articulated and said. And please respond to it. How will you check my unreasonable conduct?
If I could add to that, not only the Chief Justice's conduct, but suppose if the full court sits down and makes a rule that we'll hear cases twice a week only, we'll only work till 10 o'clock, and so be it. And firewall, good luck to your firewalls. And we're firewalled, we're just very covered. We could just hear cases only twice a day and twice a week, and just till 11 o'clock or whatever. And we could have a vacation for 6 months, or things like this. So you're firewalled, nobody can touch us, so we can just run the court the way we want, in any manner that we want. And the parliament, which represents the people, cannot come up and say, sir, what are you guys doing? Come on, have a heart.
But can I turn the example on its head? Can the parliament say that your lordships will work 24/7, 365?
जवाब दे दें हम हमारे मेरा conundrum का फिर आप confuse हो जाएंगे.
Before you reply to these questions,
Sorry.
let me ask you a question. In the Supreme Court in Pakistan, do we have lifetime appointments or do we have a retirement age?
Age of superannuation. Yeah.
So the composition of the court keeps changing.
So basically, you wait till my retirement.
Not at all.
You can't touch me till I retire.
Mr. Bhandari, the late Donald Rumsfeld said something very helpful. He said, we'll jump off that bridge when we come to it. We will deal with such autocracy when your lordship turns it.
Precisely, we'll deal with such a law when it sort of takes away our power. If it enhances our power and it makes more transparency, we will not touch it. We'll touch it when it takes away our powers or makes things more difficult for us.
My lord,
Mr. Bhandari, do we also have in this, do we also have?
Oh, sorry, sir.
Mr. Bhandari,
do we also have something?
may I ask a question, please?
Madam, do we also have something called the Supreme Judicial Council? So if we have, with all due respect, and these are hypothetical examples being given, so my question is also hypothetical.
And how effective has been the Supreme Judicial Council?
I don't think if I don't call a full court meeting, the matter
that,
can be taken to the Supreme Judicial Council. I
something
don't think you can stretch misconduct to that extent.
My lord, the moment your lordship thinks
Let
of
me
turning that
ask a question, please.
My lord, everyone here will
I think
Let me ask a
very
question.
quiet.
मैंने disturb कर देना सबको. मुझे भी इजाजत दी जाए. बस I'm sitting quiet. Sir, it says that the Act 2023, it says that whereas the Article 199 of the 191 of the Constitution provides that subject to the Constitution and law, which law the Act is referring to, which law the Constitution is pointing finger to? Was there any law at that time?
No act.
Because the rules were framed, notified in 1980. And the law has been made in 2023. So which law they were referring to?
They were not referring, at that time.
Because I think the constitutional amendment has been made by unconstitutional means. शक्ल बदल गई है constitution की.
Quite possible, but this Article 199, your lordship uses the word law. Law can include ordinances, rules. It will include the previous Supreme Court rules also, because the previous Supreme Court rules were framed in 1956, and they, under Article 268, continue as existing law. So they were also law, and they continued till they were changed and repealed in 1980 by the present rules. So at that point in time, there was no law which actually limited the power of the
guidance for making rules.
It could be, but as I said, there may be, on my reading of entry 55, there may be some law which can provide for these practices and procedures within very narrow limits, but subject to the overarching constitutional principle that nothing can be done in that law that impinges upon the independence of judiciary. And the Baz Muhammad Kakad case is squarely applicable there. There the power of the Chief Justice to constitute benches was impinged upon and it was struck down.
Mr. Bhandari, this court can revisit its own judgment by larger bench. So is it not equal to the appeal? You are overruling the judgment of 3-member bench by 5-member bench. So it is not sort of appeal.
No, my lord.
And the law, which according to you is a judge law, whether judge law cannot be managed through rules or through enactment of the parliament.
My lord, there are twofold answer to that. My lord, appeal is different because appeal determines rights between the parties themselves. It sort of does away with the concept of res judicata. If there is no appeal, the judgment becomes final, the rights are determined and res judicata applies. If you take the matter into appeal,
so it means that you are against the right of appeal provided to the general public. You say the Supreme Court can exercise that right, but the general public cannot.
No, I'm not saying that. I'm saying your power, your lordship's power to overrule previous precedent will not disturb the rights of the parties. The rights are determined. Your overruling is only on a point of law. You will declare the law, you will overrule a previous judgment. The Doso case was overruled in Asma Jilani, and in Sindh High Court Bar, all the previous validating judgments were overruled.
If this power
the rights of the parties are not affected.
If this power is structured, what effect it will have?
Well, because the difference is, once the judgment becomes final, even if the judgment is wrong, and even if it is later overruled in a subsequent case, the rights of the parties become final under the judgment. That's the doctrine of res judicata. What your lordship is alluding to is the doctrine of stare decisis. A larger bench can overrule the law declared by an earlier bench, but it cannot upset the rights that have been determined inter partes. Even the legislature can't do that. Even the legislature cannot undo the judgment, can declare a judgment of the court to be of no effect. The legislature can change the law for the future. It can take away the basis for the judgment, but it cannot simply say this is what they did in the NRO case. In NRO, they declared certain judgments to be void simpliciter, and that was struck down in Mubashir Hassan's case.
It means by overruling our judgment, we ourselves consider that judgment was wrong.
Yes.
Therefore, there must be something to revisit it.
Yes, my lord.
The parliament said, okay, do it in proper manner through the Act of Parliament.
Well, but that's a question of appeal. Appeal is different. Appeal is that the dispute is between A and B. A and B rights have been determined in the original proceedings, and then they go up in appeal and those rights are redetermined by the appellate court. The overruling doesn't take place on that basis. Overruling takes place on the basis that the earlier judgment declared the law incorrectly, and the law is now being rectified. So the rights of the parties, even res judicata applies even if the judgment which determined the rights is wrong.
It will not amount to discrimination. For once, at one time, the Supreme Court says this is wrong. On the other hand, Supreme Court said no, this is right.
My lord, but then that raises the problem of finality of judgments, because we are dealing with a human institution which is the court system. You have to have finality of judgments, finality of cases. Otherwise, why not have a second appeal then? Why not have a third appeal then? There is a problem. My lord, your lordship quoted this in
Mr.
his
Uzair
judgment.
Bandari, I must
Learned
compliment
counsel.
you on 2 counts.
My lord.
One, your extreme patience and good humor to address very different questions from all sides of the bench. And the second is your thorough being fully prepared in this case.
I'm grateful.
Do you want to add anything?
My lord.
Because our questions will never stop. I must draw a line. If you want to add something.
Yes, my lord, let me allow me to address the question.
So it's always a
Learned
pleasure
counsel.
to hear someone who is
Learned counsel, one last-
articulate. There are cobwebs in our minds as well to clear them up.
My lord.
But then we are taking away from your submissions. You want to add something?
My lord, I'll just ask for 10 minutes to address the question of appeal.
Learned counsel, just one last question.
My lord.
You represent a very, it's a political party. Maybe tomorrow it is in majority in the parliament. From your arguments, what I've gathered is that you actually do not repose your confidence in the parliament. What you have said is, as I've understood, that this is a very good law, but in future the parliament may make a law which may have effect on the independence of judiciary. There is no fundamental right that the political party is, argued that is enforcing. They say it's a good law, it should happen, but their apprehensions have been expressed against the parliament. So, do you think it's a matter which should have in the first place been taken up under Article 184(3)? Because everyone, and kindly if you can cite any example in any jurisdiction where a good law, a law that actually ensures access to justice, may have been struck down by any court.
My lord, I'll do that. The Indian Supreme Court did that in the Advocate on Records case 2016, volume 1, 2016 volume 1 SCC, volume 5 SCC page 1. Their National Judicial Appointment Commission had been reconstituted by the 99th Amendment of the Constitution. They put in experts from the public to help and to sort of advise in the process of appointment of judges. That law was struck down by the Indian Supreme Court. A constitutional amendment was struck down because it violated the independence of judiciary, even though, and this is most critical, and I'll...
Learned counsel,
Learned
counsel, here in this case, it is promoting and advancing the independence of judiciary.
It is not. My lord, I am not for a moment conceding that this is a good
as
law.
a political party,
It is not a good law.
This is your stance.
My lord, it is not my stance, and I am not conceding that it is a good law. It is half-baked. It creates more problems than it solves. It's being dressed up as a good law. For example, if your lordship actually decides to turn the autocrat that your lordship just said you were, where is the provision in this act which says that how will the cases be fixed? Section 2 simply says the committee will constitute benches and allocate cases to them. What if your lordship decides that despite that allocation, I am not going to fix any case?
We can
This
frame
act
the
doesn't-
rules.
नहीं,
We
because
can frame the rules for that.
ये
So, it's a
देखिए
half-baked
वो
bill.
मेरे
We
दोनों
can
तरफ
frame the
दो फरिश्ते जो बैठे हैं वो मुझ पे नजर रखेंगे, आप फिक्र ना करिए।
नहीं, वो-
इधर और भंडारी साहब
नहीं,
एक कमिटमेंट तो आप फिर कर ही रहे हैं ना आज कि जब आप की पॉलिटिकल पार्टी अगर कल इलेक्शन जीत जाती है तो पहला बिल आप पार्लियामेंट में इसको रिपील करने का डालेंगे ना।
My lord, मैं तो ये कमिटमेंट नहीं दे सकता।
अब इतना बुरा कानून है, फौरन रिपील करवा लीजिएगा। हम फिर पुराने उस पे चले जाएंगे। ये आप कमिटमेंट नहीं दे सकते, ये तो अजीब बात है। इतना बुरा कानून है मगर मैं ये कमिटमेंट नहीं दूंगा।
नहीं, हो सकता है इसको कॉन्स्टिट्यूशनली प्रोटेक्ट
तो शायद आपको सूट करे,
अगर अपील दे दे इसको
तो शायद सूट करे, इसलिए
मतलब मैं
ये देखिए ये बात असूली बातें होती है ना।
क्या होगा जी वो तो मैं नहीं कह सकता, वो तो कोई भी नहीं कह सकता।
चलिए अब देखा नहीं, लेट्स वाइंड इट अप।
मैं सिर्फ इस पे सर ये जो मैं आपको माय लॉर्ड द जजमेंट आई रेफर्ड in para 990 of that judgment there is very detailed discussion on how the collegium system in India has totally destroyed matters. Lordship, no, in India the power of appointing and recommending judges for appointment does not vest in the Chief Justice, it vests in the collegium of 5 judges. And this para 990 at page 689 deals with the problems that the collegium system caused. And that goes on and on. Favoritism, nepotism, abuse of power. But they nonetheless said, we are not letting the parliament
Judicial Commission and Parliamentary Committee भी तो collegium ही चल रहा है ना, तो वो against the independence of judiciary नहीं है Parliamentary Committee.
नहीं, वो आपने uphold कर, मैं बात और कर रहा हूँ, मैं ये कह रहा हूँ जो my lord ने सवाल पूछा था कि इधर इंडियन सुप्रीम कोर्ट ने एक्सेप्ट किया कि बहुत प्रॉब्लम्स हैं कोलिजियम सिस्टम में, हम बाहर वाले को फिक्स नहीं करने देंगे. माय लॉर्ड विद रिस्पेक्ट, अगर आप अपने प्रॉब्लम्स जो आपकी जुरिस्डिक्शन में है वो बाहर वालों को सॉल्व करने देंगे, फॉर मी दैट ब्रिंग्स बैक सेलस पॉपुलाई सुप्रीमा लेक्स डॉक्ट्रिन ऑफ नेसेसिटी. हर मार्शल लॉ भी इसी बेसिस पे लगा
सुप्रीम कोर्ट के 3 जजेस हैं, चीफ जस्टिस एंड 2 जजेस,
मार्शल लॉ लगा देते हैं,
चीफ जस्टिस एंड 2 सीनियर जजेस इन द कॉलेजियम. तो ये बाहर वाला कौन है यहाँ पे?
इधर सर,
यहाँ पे अगर कमेटी है तो बाहर से कौन आ रहा है?
सर मैं और बात कर रहा हूँ.
नहीं, कॉलेजियम सिस्टम अच्छा नहीं होता,
ये बताइए,
उसमें नुकसान होता है.
As a political party, do you support the powers vested in the Chief Justice and not in 3 judges?
No. I'm saying it should be maybe more than 3 judges. But
Learned Counsel,
I
more
am
than
not in favor. I'm not saying that the Chief Justice.
Counsel, you have to be very clear. Do you support the previous system where the Chief Justice had absolute discretion?
I don't support that.
So it's a good law.
It is not.
Secondly,
It is not. My lord, I don't concede it's a good law. Because from this extreme, you don't necessarily go to that extreme. You go step by step.
Counsel, that is your question.
If tomorrow they do take my advice before enacting law, I will advise them to.
में सुप्रीम कोर्ट की डेफिनेशन है, उसमें चीफ जस्टिस एंड जजेस,
सब जजेस,
जो चीफ जस्टिस के पास इख्तियारात हैं 191 में कि वो कुछ एडमिनिस्ट्रेटिव काम अपने जजेस को देते हैं. लेकिन अगर यहाँ पे अंडर द लॉ कुछ इनको ये अथॉरिटी मिल जाती है, तो जो कॉन्सेप्ट ऑफ इक्वलिटी है अमंग्स द जजेस अपार्ट फ्रॉम द चीफ जस्टिस, वो कॉम्प्रोमाइज नहीं होगी.
केस में एग्जैक्टली यही हुआ था कि स्टैट्यूट के थ्रू चीफ जस्टिस की कॉन्स्टिट्यूशनल पावर्स को चेंज करने की कोशिश की गई और उन्होंने कहा नहीं हो सकता. मेरी तो सबमिशन ये है, मैं बिल्कुल मुतलकुल ऐलान चीफ जस्टिस के हक में नहीं हूं.
चीफ जस्टिस के पावर कहीं डिफाइंड है कॉन्स्टिट्यूशन?
कई जगह है. फॉर एग्जाम्पल
एक जगह बता दे.
नहीं, वो सर जैसे 140s में चीफ जस्टिस आर्बिट्रेटर्स अपॉइंट कर सकते हैं.
As far as the working of the Supreme Court and the constitution of the benches,
the subject matter of this act, my lord is asking, yes, of course, the chief justice powers are mentioned in various provisions. Regarding the subject matter of this case, is there anything which can be utilized?
Not except the constitutional convention, that appointment of that constitution of benches is your prerogative.
You see, 191 में इसीलिए rule making power दी है कि ये constitution of benches, distribution of work, committees, review, revisions, whatever, उसके जो rules हैं वो Supreme Court खुद बनाए. And a full court in 1980 did make those rules, और उससे पहले भी rules बने थे जो, I mean, which followed the constitutional command. तो वो constitution में तो ये सारी चीजें नहीं लिखी जा सकती, इसीलिए rule making power दी गई. So let's move on to the appeal bit.
My lord, the appeal, and I'll try it. My lord, there is one direct precedent which deals with the question of appeal and such similar matters, which is Sabir Shah's case. PLD 1995, Supreme Court 66. Now, what had happened in that
दोबारा बताइए PLD.
PLD 1995, Supreme Court, page 66. Now, my lord, what had happened?
ये दिखाइए जी.
What's the contention?
PLD 1995.
Contention क्या आपकी?
जी मेरी इस केस में ये था, the Political Parties Act was amended, and in the case of defection, the power was conferred, power of adjudication was conferred on the Election Commission. in terms of Article 63(2). And appeal against that order of the Election Commission was provided direct to the Supreme Court. And that appeal was struck down by this Honorable Court in this case by saying that where the original forum, Article 63(2), is created by the Constitution itself, then an appeal, and the Constitution does not provide a further remedy, then an appeal against that cannot be provided by ordinary legislation.
ये कौन सा paragraph है?
This is, my lord, first of all, this is Justice Sajjad Ali Shah, his lordship as then was the Chief Justice. He wrote for the majority. There were some dissents also. This is para 14 at page 99.
What was the reason given for it?
Because the sub-constitutional legislation cannot in effect amend a constitutional provision.
Did they discuss 55?
They did not. There's no discussion of 55 here.
Para 14 पढ़िए जरा.
Para 14, I read the first 4 lines. Determination of question of forum. इससे पहले, your lordship may kindly see page 105 where the provision in question is reproduced. 105.
जी. If a member of a house.
जी.
लेजिस्लेटिव कॉम्पिटेंसी की बात होगी ना?
Legislative competence.
तो 55 की और किसकी डिस्कशन की?
41 की, because election से related था, Political Parties Act 40 entry 41 से आया था. If a member of a house having been elected as such, a candidate or nominee of political party, or having been elected as such otherwise than as a candidate or nominee of a political party, and having become a member of a political party after such election, defects or withdraws himself from the political party, he shall from the date of such defection or withdrawal be disqualified from being a member of the House for the unexpired period of his term as such member, unless he has been re-elected at a by-election held after his disqualification. 2. If any question arises whether a member of a House has become disqualified under subsection 1 from being a member, the question shall, on a reference by the leader of the parliamentary party concerned, be determined by the Election Commission. 3. An appeal against a decision of the Election Commission under subsection 2 shall lie to the Supreme Court within 30 days of the decision. So this, then your lordship may kindly...
Entry 41 में तो कोई बार नहीं था, उनको तो 55 में ही देखना चाहिए था.
55 इसमें डिस्कस नहीं.
41 में क्या प्रॉब्लम? 41 तो इलेक्शन से डील करता था, तो आप क्या तो आर्गुमेंट है कि उसको डील करते हुए you can provide all the appeals and everything.
नहीं, but मैं
competition commission.
यहाँ पे और बात आ गई. मैं यहाँ पे तो ये है कि आपको अगर कॉन्स्टिट्यूशनल फोरम है, जैसे कि इलेक्शन 63(2) में है या 184(3) में है, उसके खिलाफ आपको अगर अपील देनी है तो वो तो एक्सप्रेस आपको पावर चाहिए बाय और अंडर द कॉन्स्टिट्यूशन. 184(3) में भी नहीं है और उन्होंने कहा जी 63(2) में भी नहीं है, तो वो तो उस 55 तक आप पहुंचेंगे ही नहीं क्योंकि एक्सप्रेस ऑथराइजेशन ही नहीं है. अनलाइक मेरी रीडिंग के मुताबिक इन माय हम्बल सबमिशन 2043 इज डिफरेंट. वहां पे
और कहा कि 41 में पावर नहीं है.
नहीं, उन्होंने तो ये पढ़ लेते हैं. उन्होंने ये कहा कि जी वो फोरम अगर कॉन्स्टिट्यूशन ने एक ही फोरम दिया है और उसके खिलाफ रेमेडी नहीं दी तो फिर आप उसके खिलाफ रेमेडी थ्रू सब कॉन्स्टिट्यूशनल लेजिस्लेशन नहीं दे सकते.
ऐसी बस कह दी.
I think that's, I mean, you can't amend the constitution
anything more?
Or ordinary legislation.
Anything more?
दूसरा फिर इस पे आप देख ले सर पैरा 34 Justice Fazal Kareem's opinion at 259
इसी केस में
and then the discussion by